Let's start off with Australia, which will soon introduce a law to make social media giants provide details of users who post defamatory comments. Now, the new law will have a complaints mechanism so that if somebody thinks they're being defamed, bullied or attacked on social media, they will be able to require the platform to take the content down. And if the content is not withdrawn, a court process could force social media platform to provide details of the person who posted the comment. Now, this development comes after Australia's highest court ruled that publishers can be held liable for public comments on online forums. Those are the details here coming in. So essentially, this is Australia now, which has made social media platforms liable for comments. So this is a system that has been put in place to ensure that defamatory content and remarks are removed, and the person actually facing that defamation can ask the platform to delete the material. Even the courts could step in here as well and ask the platform to identify the trolls. So the question really here is whether or not other countries will follow suit, and should other countries follow suit. Pavan Dugal, cyber expert, is joining us at this point in time. Thank you so much, Mr. Dugal, for joining us. Your perspective on what Australia has done here. Of course, in India, of course, we've been struggling with trolling. Several people have been victims of online trolling, and the worst kind of it. And very often it's very difficult to really identify who is behind it and how it's really happening. So what do you make of this move that Australia has done, and whether or not other countries can actually emulate it?
Well, what Australia has done is actually going to be music to the ears of victims of abuse and online trolling, bullying, harassment and defamation that's continuously happening on social media platforms. Traditionally, all these companies who are social media platforms have all been hiding behind the statutory exemption from legal liability granted to them under Section 230 of the Communications Decency Act of the United States of America. But now, for the first time, the Australian High Court in September 2021 has held that these platforms can be made liable for user-generated content on their platform defamatory, and that it's a mandatory obligation of the platform providers to provide the real identity of the concerned person who's behind such trolling or defamatory content. So I think for the first time, users will now have more effective access to remedy. Right now what happens is something defamatory gets written to you, you write to these guys, they would invariably not respond, otherwise they will want you to get a court order, which will take a long period of time. And by that time, you continue to suffer in silence on a 24/7 basis, because your defamatory material, which is targeting you, continues to be made available online. So I think it's a great move forward. It's basically a vindication of protecting the rights of the victim. And I think it's the right step to go in the right direction. And India can potentially take a lot of potential encouragement and inspiration in coming up with similar kind of norms. We have come up with some half-baked norms under the IT Rules 2021, where we have said that as far as possible, they ought to tell us the identification of the person behind the illegal content. But I think the moment to start enforcing the criminal liability of these platforms and data repositories, then I think the picture color changes, and then there will be increasingly falling into line. So hopefully what Australia has done could be beginning of a new era, a new chapter in the evolving cyber legal jurisprudence globally, and hopefully that could become a starting point for other countries, including India, to follow this and come up with their own customized models so as to force these so-called data intermediaries to act and ensure that cyber defamation, nuisance and cyber trolling does not go unregulated on their platforms.
Yes, absolutely, Mr. Dugal. And just to take that point forward on India's new IT rules, because that was one aspect here that the identities of such trolls would perhaps need to be discussed. But like you pointed out, there is still some more steps, and Australia has gone that extra mile in these new rules that they have come up with. But from India's current new IT rules and getting to where Australia really is, what more ideally needs to be done?
A lot more needs to be done by India to come up to the place where Australia has currently reached. First and foremost, the IT Rules 2021 are at best only a half-baked approach. Though under Rule 7, we have provided for the criminal liability for the said portals and the data intermediaries and the top management. The reality is, barring registration of 4 FIRs against Twitter in 4 different states, this kind of a provision has not been invoked. And that being so, an impression is often getting that India is somewhere down the line only coming up with paper tiger provisions which have no effective remedy. Also, a number of these service providers have already challenged the constitutional validity of these IT rules before different high courts, and we'll have to wait for the decisions. But having said that, it's important to note that no single court of the country has stayed or set aside those portions of the provisions of the IT rules 2021 which mandate these service providers to give details. And also, I think one thing missing under the IT rules is the specific focus whereby we specifically straddle these data intermediaries with certain cogent and mandatory duties that they have to do in order to prevent online bullying, online trolling, harassment and cyber nuisance on their platforms. Merely hiding behind the cloak of anonymity is no longer the need of the hour. The so-called honeymoon of the intermediaries under the Indian cyber law is over, but there's still an extended honeymoon that's going on. That extended honeymoon also needs to come to a close, and the law needs to come up in crystal clear terms to tell them, hey guys, better well start acting and reduce the menace of these online trolling on your platforms. Otherwise, be prepared to go to jail or be prepared to face all kinds of legal consequences under the IT Act and the Indian Penal Code. But for that, we require political will. And political will, if that comes in, we can come up with very strong provisions by coming up with secondary legislation under Section 687 of the Information Technology Act 2000 without even going to the Parliament. So all eyes will be on the government of India as to how and in what particular manner it will want to proceed forward in terms of making these intermediaries more accountable and responsible.
Yes, absolutely. And you spoke about political will, Mr. Dogal. The fact is here that even the current IT rules, let alone if we go the extra mile further, the question of execution and implementation is also the other point where that can more often than not usually be a big hurdle. Even if laws are good, the execution is always a big question mark.
And that's the one big area that India needs to work on. We have been having wonderful paper tiger legal provisions, but they have not really translated into effective remedies. Today, if something gets written against you online, try writing to these service providers. First and foremost, they'll often not respond. Even if they respond, they will say, look, get me a court order, because your Supreme Court is telling us, as an intermediary, don't do anything till such time you get a court order or an order from a governmental agency. And trying to get a court order or an order from a governmental agency in these contexts, in today's times, by a normal person, takes months, if not years. So in a scenario like this, effectively, the victim has to suffer in silence and constantly suffer this constant 24/7 defamation, derogation, and trolling. So somewhere down the line, the onus has to be on the government. Now that you have Rule 7 of the IT Rules 2021, which says that the moment these service providers do not comply with the parameters of the IT rules, their statutory exemption from legal liability or the Suraksha Kavach that the law provides to them is going to be taken away. Please snatch them, these kind of Suraksha covers from these kinds of service providers by operation of law. Please invoke criminal liability so that the message needs to go loud and clear. Just filing 4 FIRs against one service provider is not enough. Mind you, we are now almost the end of this year, and in the last 8-9 months, barring 4 FIRs, no action of any criminal nature has been initiated against any service provider who's in violation of the IT rules. That itself shows that India needs to work tremendously in terms of enhancing the quality and the efficacy of its enforcement of the provisions of existing law.
Absolutely, Pawan Dugal. In fact, that is, of course, some very important points that you've raised here with respect to this. Now, in terms of Australia, of course, has come to this. You mentioned that this hopefully will be the point or starting point as far as other countries are concerned. But do you really see India aside, other countries beginning to adopt such kind of rules?
Absolutely. There's now beginning to become a new change in the mindset. It already started way back with the Christchurch attacks, when this guy landed up, wounding and killing a number of people and broadcasting it live on Facebook. That's why when the Christchurch declaration took place, The nations who signed the Christchurch declarations, including India, reiterated the fact that intermediaries cannot be mute spectators while illegal things happen on their network, and they need to be made more accountable. Now, it's in this context that we are now beginning to find new legal provisions coming in. During the coming of COVID-19, a lot of countries have come up with dedicated laws. In my new book, New Cyber World Order Post-COVID-19, I've argued that through these laws, countries are increasingly trying to, shall I say, consolidate their stand and make these intermediaries and service providers more responsible. And when you look at these various cyber security laws that are passed in different nations, whether it's China, whether it's Singapore, whether it's Thailand, or even whether it's Australia, the focus is increasingly on putting up new compliances for these service providers and making them criminally liable in the event they do not comply with these compliances. So I think a trend is definitely coming in. A lot of countries would be now required to revisit their existing cyber legal frameworks so as to have a revisit vis-a-vis this so-called carte blanche freedom or immunity given to these service providers due to whatever happens on their network. Clearly, in this new world where fake news is all around us and where all these service providers are milking your country's digital markets, it's time to make them more accountable, more responsible by ensuring that they comply with the mandatory provisions of your law. Otherwise, there's nothing stopping the governments of the respective countries to start criminal and civil prosecutions against these service providers to bring home the message of deterrence. Once the message of deterrence starts coming in, then to a large extent, a bigger message is going to actually be spread in the ecosystem.
Absolutely, Pawan Dugal. Thank you so much for joining us with your perspective.